Hey folks, just a few weeks ago I gave a major presentation to the Second Amendment Foundation and the Citizens Committee for the Right to Keep and Bear Arms as part of their AMM-Con conference out there in Salt Lake City, Utah. During that event, I should note, I was very humbled to receive the 2025 Gun Rights Defender of the Year Award from the Citizens Committee for the Right to Keep and Bear Arms. I'm very humbled and honored to receive such an award. But as part of that weekend, I also gave this major presentation that went on for almost an hour, a super deep dive in the Supreme Court jurisprudence, Second Amendment jurisprudence, how to analyze the courts, and explain these things to journalists and others. So I thought you might enjoy hearing my remarks, which I will play for you right here and right now.
Professor Mark W. Smith is a constitutional lawyer and hosts the popular The Four Boxes Diner YouTube channel, which addresses Second Amendment scholarship, history, and legal issues. Mark is a New York Times best-selling author who frequently appears on the Fox News channel and also Gun Freedom Radio. I'm just going to brag a little bit. He's been my guest on our show. And without further ado, Professor Mark W. Smith.
Thanks, Cheryl. Thank you very much. Thank you, Cheryl. No, I don't use PowerPoint because, you know the famous saying, power corrupts, and PowerPoint corrupts absolutely. So I see we have effectively Comic-Con, the FanX across the street, where everyone's in a costume. So I put on this suit today and I walked across the street and everyone ran scared to death from me. They said, "What's your costume, sir?" I said, "I'm an intellectual property lawyer." All right. So we're going to talk about the Second Amendment in the courts. And here's the reality. This is the cutting edge, the most important area of constitutional law in a generation, the Second Amendment. And that's the case for two reasons. One, a big picture political reason, and number two is, of course, guns. The fight over the courts and how to interpret the Constitution is a subject of a battle that's been going on for decades, and we're finally, to some degree, in the driver's seat with the Supreme Court. And that fight is between the notion of originalism versus the living Constitution. Now, we in the Second Amendment community want to support the originalist point of view because the originalist point of view basically defers to the greatest extent to our founding fathers who believed that protecting liberty and freedom was the ultimate value and norm in a society. That is in contrast to the anti-gunners and more globally the pro-government forces who believe in a living constitution where the Constitution can be adopted by unelected judges to fit the needs that they deem appropriate, which is basically advancing the progressive cause. And if you want to understand the outcome of living under a living constitution, look no further to modern day Europe, which is where the American progressives want to move us to as a country. Under modern day Europe, you see you have no free speech rights except to parrot the party line. You have no right to keep and bear arms. You are governed by not we the people, but they the elites, they the experts, and the bureaucracy. That is where the American progressives want to move us to, but to move us there, they need to do two things. Number one is they must disarm us, which of course speaks to the Second Amendment, which is why the anti-Americans want to destroy the Second Amendment, because you cannot bully around an armed population. And Europe has become disarmed and thus easy to bully, as we see from people getting arrested by memes and tweets and the like over there. So again, understanding the rule of law, the Second Amendment, the Constitution is mission critical, not just for the Second Amendment, but for the entire experiment of American liberty versus modern day European socialism. And keep in mind, the reason why the Second Amendment is uniquely important to this battle between originalism on the one hand and the living Constitution embraced by people like Ruth Bader Ginsburg on the other hand, is because unlike all other areas just about of American constitutional law, because the liberal judicial activists had no interest in the Second Amendment, they, thank the Lord, left it alone for decades. So that allowed the US Supreme Court now to essentially write on a blank slate. Whereas all other areas of American constitutional law, like Humphrey's executor, which is dealing with this FTC Federal Reserve thing, you have to overturn a 1930 Supreme Court precedent because they went out and touched it. There is no 1930 precedent involving the Second Amendment or 40 precedent or 1950 precedent that we have to overturn to win for our rights. That means the Supreme Court today is really working on a tabula rasa a plate or a blue ocean, whatever metaphor you want to use. There's nothing they need to overturn to advance the Second Amendment rights, and thus it is the perfect opportunity for the Supreme Court to do the experiment of originalism because there's nothing they need to unwind from those decades of liberal judicial activism. That's why the anti-gunners are so desperate and the progressive movement is so desperate to destroy the Second Amendment movement in America and the way it's interpreted in the courts, because if they can destroy it in the courts and prevent originalism from succeeding as a methodology for applying the Second Amendment, it means they will have destroyed the entire approach of originalism for all aspects of American constitutional law. We are the tip of the spear on this battle, and it's not just for our rights to keep and bear arms, it's for the entire constitutional experiment as understood by the Founding Fathers. So with that said, I want to talk today about how to understand Second Amendment challenges in the courts. Because there is a lot of lingo and there's a lot of misinformation out there for two reasons. One of which, of course, the anti-gun journalists, the anti-gun media doesn't want to talk about the Second Amendment correctly. And obviously there's a lot of people with money out there trying to muddy the waters. But I'm going to clarify that for you. To begin with, I'm assuming most of you are in the media, you're journalists. There's three buckets of issues, or three buckets of cases you should just be aware of when you see a case that breaks or a story that breaks. And I put them into three buckets. First is straightforward Second Amendment cases. Does this case involve the interpretation of the Second Amendment? Yes or no? Then you have another bucket, which I call the regulatory bucket. This is whether or not ATF is behaving itself. It's whether the EPA is behaving itself on hunting grounds and wildlife conservation. So there's the regulatory bucket, which to some degree, this is going to sound a little controversial, but to some degree, the regulatory bucket today is important, don't get me wrong, but it's a little bit less important because there's opportunities to fix it with the Trump administration able to make changes because, of course, we have Trump in there with sort of supporters, so the regulatory thing can be fixed without going to the courts as much because I think there's a goal, at least, of the Trump administration to do better on that front than Biden did. And of course, the third bucket is what I call the lawfare bucket. These are lawsuits brought against the gun industry, gun supporters, YouTubers, whatever it is, to try to thwart that. So again, you got the Second Amendment bucket, the ATF regulatory bucket, and the third bucket of cases that you need to be aware of is what I call the lawfare lawsuit bucket, where you sue a gun company because some nutjob psychopath went out there and misused a gun, and of course they sue the gun company or the ammo company. So whenever you report on this stuff, break it down into one of those three buckets. Now, I want to turn specifically to some of the lingo of Second Amendment challenges because this is where, and by the way, when it comes to Second Amendment challenges, this is the language I encourage you to use and how to talk about it. And you'll see why. Because a lot of journalists do not get this right. They misconstrue things. Sometimes it's on purpose, sometimes it's not on purpose. To begin with, keep in mind there's two types of cases when it deals with Second Amendment challenges. Think about this for a moment. You have civil lawsuits brought by things like the Second Amendment Foundation, where the plaintiff in a civil case is what I call, listen carefully, write this down if you're reporting on this, you're the Second Amendment rights claimant. The Second Amendment rights claimant. And what is a rights claimant? You're the person that's claiming or asserting a right. Now, the Second Amendment rights claimant arises in the context of a civil lawsuit brought by, let's say, the Second Amendment Foundation. Those are the plaintiffs that are suing to challenge the gun control law. But sometimes you have a criminal defendant, i.e. Zacky Rahimi, who's also asserting Second Amendment rights in the context of defending against a criminal challenge. So, for example, George Peterson in the U.S. Court of Appeals for the Fifth Circuit dealing with suppressors involving the NFA, he would be an example of a Second Amendment rights claimant, even though he's a criminal defendant. So always keep in mind that you can have Second Amendment rights claimants either in the criminal cases or in the civil cases. Now, step back briefly, we also want to understand that from the Second Amendment point of view strategically, we really want civil cases to go to the Supreme Court and not criminal cases, because this Supreme Court does not like criminals. If you look at their sort of record when it comes to applying the death penalty and not staying death penalty executions and whatnot, needless to say, this is a court that doesn't generally like criminals, and as a consequence, we don't want criminals to go to the Supreme Court arguing for Second Amendment rights because it's not as sympathetic, and the old saying, bad facts make bad law, is a truism, right? So we don't want Zaki Rahimi representing the Second Amendment in front of the Supreme Court for obvious reasons. In contrast, Merrick Garland and the Biden people and the liberals and the anti-gunners want to push to the Supreme Court the criminal cases because, again, they want this court to rule against the Second Amendment because they don't like criminals. So we always understand that dynamic when you're doing reporting. Is this a civil case or is this a criminal case? And generally speaking, we want civil cases to push forward. We don't want criminal cases because of bad facts and the sympathy factor. Now, every time you come across a Second Amendment case, you should ask 4 questions. And I'm going to give you the questions, and then we're going to break down how to assess each question. There's the who, the what, the how, and the where. The who, the how, the where. The who, the what, the how, and the where. So what does that mean? Let's think about the text of the Second Amendment, the operative text. The right of the people to keep and bear arms shall not be infringed. So the who is the people, right? The what is arms. What are arms? So again, when you're dealing with the who, it's who are the people. When you're dealing with the what, it's what is the arm? What are the arms? Is this an arm? Is it not an arm? When you're dealing with the how, you're asking the question of how is government regulating the people's ability to have arms, and then I add the where, which sometimes gets into the issue of sensitive places, or if you're from Maryland and you want to go to California and you're not allowed to have a gun in California because you can't get a license, that's another example of a where problem. So always ask yourself when you look at a case or a controversy, you ask the who, the what, the how, and the where, just to start. So let's talk about these issues. Who is the who? Well, the text says the right of the people. So when you're talking about the who, you're talking about the people. Who are the people? Okay, let me step back briefly and give you some very, very good news that the anti-gunners don't want you to know, and that's this. You don't need to watch the 4 Boxes Diner or to read a dictionary or to marry a lexicographer to understand what the words of the Second Amendment mean, because the United States Supreme Court already did it in Heller. They already did it. They did the job. Understand when you're trying to interpret the text of the Second Amendment, we'll get to the history stuff later in a moment, but when you're trying to interpret the text of the Second Amendment, all you need to do is look at the Heller case and every term is defined. Because to interpret the text of the Second Amendment, and this is important because the anti-gunners are trying to trip you up on this, but don't let them trip you up. When you're interpreting the text of the Second Amendment, it is a linguistic or a semantic exercise. It is a linguistic or semantic exercise, which means you're interpreting language, you're interpreting words. You're not doing interest balancing, you're not studying, period undergarments from the Victorian era, you're doing none of that. You're interpreting words. You will sometimes see the phrase that the Second Amendment words is text as informed by history. Ever see that language? What that means is this. You interpret the text of the Second Amendment as informed by history, which means at the time the text was written. Because the whole notion of originalism is, what was the public understanding when that part of the Constitution was adopted by we, the people? And that is exactly what the Supreme Court did in Heller. In Heller, they did the who, and what they said with people, and what they said with all this is, the people means every member of our national community, which is at a minimum means American citizens. It probably means green card holders. It does not mean illegal aliens, okay? But at a minimum, it means all American citizens. That is the people. And then what does to keep mean? They told you in Heller, to keep means to possess. It's not rocket science. And what is to bear? It means to carry. And what is an arm? Heller defined that as well. Anything that can be used offensively or defensively is an arm. And the only other curve I'll add to that is the Supreme Court has said because you are dealing with keep and bear arms, the only arms that are protected as a matter of text are those arms that are bearable, because you have to have an arm that can be borne, which means carried. So it eliminates, sorry, I know some people don't like this, but the reality is textually it eliminates things like battleships, okay? Because you cannot carry a battleship. So that is how the Supreme Court understands the text. So again, those are defined not by me, but by the US Supreme Court already. And they're very straightforward. Now, that is how to understand those terms. Turn to Heller, they define all those terms. Now let's get a little bit more detailed in terms of sort of some of the controversies that come up in this context. Okay, once you understand that step one is to interpret the text of the Second Amendment as the matter of plain text, if a modern-day gun control law implicates that, the burden shifts to the government, all right? The burden shifts to the government. But to do what? Okay? To do what? So if you have a regulation, the how, that restricts or regulates a ability of any member of we the people to possess or to carry a bearable arm, that means that the text has been implicated by the modern-day gun control law. Once those fingers touch between the modern-day gun control law and the Second Amendment's plain text, the law is presumptively illegal, unconstitutional. The presumption is unconstitutional. This is not like new law, if you think about it. If I indict James Comey yesterday, the presumption of innocence triggers. James Comey is presumed innocent, and the burden of proof is on the government to prove in a court of law that he's guilty. The same dynamic applies in the context of the Second Amendment. Once the plain text of the Second Amendment is implicated by modern-day gun control law, the presumption is not just that James Comey is innocent, but the presumption is that the modern-day gun control law is unconstitutional, unenforceable. Okay? So the burden shifts to the government in the same way it shifts to the government when I'm indicted for a crime. The burden is on the government to show beyond a reasonable doubt I'm a criminal and that I'm guilty, right? In this context, the burden shifts to the government to show there's a long-standing, well-representative historical tradition of some sort of firearms regulation that is sort of an exception to or overcomes this burden of the presumption of unconstitutionality. Now, I just want to digress briefly about the word infringe. Okay, this is sophisticated stuff, but you'll totally understand it when I say it, although a lot of people don't get it, okay, at the first. It's a little counterintuitive. The text of the Second Amendment, the right of people to keep and bear arms shall not be infringed. What is the one word that the U.S. Supreme Court has not defined in Heller, in Bruin, or in Rahimi? The answer is infringe. They've not defined to infringe. Why is that? Why is that? Is it because they just overlooked it? Here's why, and this is a little counterintuitive, but you'll understand it once I say it, and that's this. If you think about it, the plain text analysis, which is linguistic and semantic, modern gun control law implicates that, burden shifts to the government, and then there's this historical tradition of firearms regulation analysis that must be done. At the end of all of that work, at the end of that test, it spits out an answer of whether or not an infringement has occurred. So when it comes to what is an infringement, the infringement or to infringe really is the product of or the outcome of the methodological approach of Heller and Bruin of plain text, burden shifted to the government to see if the government can show a longstanding historical tradition of firearms regulation. Once you've done all that analysis, you reach an answer. That actually is whether or not there's an infringement. So if you want to understand, so people write these often liberals write these long articles about what the meaning of infringe. It doesn't even matter. I mean, I can address all their arguments in a heartbeat, but you don't need to worry about that, because the right way of doing it is to understand that text and then history gives rise to an answer, and that answer tells you whether or not there's an infringement, and that's how you figure out the definition of infringement for the purposes of the Second Amendment. And that's why the Supreme Court has not defined to infringe, because it is the outcome of the methodology. Does that all make sense? Okay. So, we've talked about the plain text. We understand that's semantic and linguistic. And now let's talk about the history. We know the burden shifts in the same way a burden shifts to the government in a criminal case. This is not new law. This is basic Anglo-Saxon, Anglo-American law, right? There's nothing new about what the Supreme Court is doing here. This is the way that the Supreme Court interpreted the Constitution from 1791, Bill of Rights, all the way basically through FDR. So what we're really talking about here by going back to originalism or the proper interpretation of the Second Amendment is a restoration process. So again, when people like to say there's a new method of interpreting the Constitution, there's a new method of interpreting the guns, the answer is no. We are restoring the proper understanding of the Constitution to where it never should have left. So always remember when you write up about this stuff, this is the process of restoration, or you could refer to it to some degree as a counter-revolution against left-wing judicial activism in the proper interpretation of the Constitution, which again we're seeing, for example, right now where the Supreme Court just granted cert. In that case involving Rebecca Slaughter and the FTC, they are going to overturn the Humphreys executor case, which basically took away power from we the people and took away power from the president and gave it to an unelected group of people in a multi-member board. That's why things like Humphreys executor have to be overturned to give the president back the powers that was taken away from him through congressional statute. And that's the sort of thing that this current Supreme Court is all about, restoring the American Constitution to a place it never should have left, and that includes the Second Amendment as well. Okay. Are we all... any questions real quick? Are we all okay? Plain text, Burden? Let's talk about history. Right off the top, do not get sucked in to the silliness that you see from anti-gun courts and anti-gunners and journalists that say things like this. Whoa, we need historians. I'm not a historian, I'm just a judge, right? BS. Why is that? The type of history we're talking about, when the Supreme Court talks about the historical tradition of firearms regulation, that the government must show to overcome the plain text, let's say, to show modern gun control law is constitutional. It's a particular kind of history, and this is very important to understand this. It's not just generic history, like I'm standing on the river watching the history go by and thinking about it. No, it's a historical regulation of firearms, right? It's the historical tradition of firearms regulation. What is a regulation? A regulation is a law. Who is the expert? Who are the experts in understanding the history of law? That would be lawyers. If you think about it, every single case requires judges and lawyers and others to go back in time and do history, both legally and factually. Let's just take the most basic case in American life, a car crash. And someone is sued over a car crash, the most basic thing. First of all, what happens? The first thing that happens is someone's got to go back and get the relevant law for dealing with car crashes and allocating liability and jury instruction, where they're going back in time to grab existing law to apply to today's car crash case. And then they're going back in time to do what? They're going back in time to see who went through the red light. So both history, right, the whole process is historical in nature, both finding the relevant law and applying it to this case today, as well as going back in time to figure out whether or not somebody did something wrong at the intersection. It's all based on history. So for those people that don't like guns to say, history is so hard and we need historians, and of course all of whom are left-wing academics who hate guns, we need to consult with them. BS, because every single day in American life, in American courts, all we do is history. Historical facts and historical law. Never forget that when people talk about we need all this history, because you simply don't. You simply don't. You need a particular kind of history, which is the history of law. And by the way, the ultimate historical law is what? The United States Constitution. Who do you think set 6 years to be a senator, 4 years to be the president, 2 years to be a member of the House of Representatives? Who do you think said we have to have a census at least every 10 years? It doesn't say, by the way, only 10 years, only every 10 years. It means you can, in theory, have a census every year, but I digress on that controversy. But the point is that, guess what? This is the Constitution. No one objects to the text of the Constitution when it comes to 4 years, 2 years, that you got to be 25 to be in Congress, you got to be like 35 to be the president, whatever. No one objects to those provisions, right? But somehow, when it comes to the Second Amendment, it's like, oh boy, it's so hard, we can't figure this out, it's so old. Yeah. But we do everything else by the Constitution except the Second Amendment. Never forget that. Use these in your articles, use these to talk about these issues. Now, let's talk about historical laws. So we know we got to look at historical laws, which means that if somebody writes a book on, the type of underwear that Thomas Jefferson wore, it's history, but it's not the kind of history the Supreme Court cares about that would allow the government to overcome its burden to show that modern gun control law is consistent with the Second Amendment. Again, it's a particular type of history. It's the history of law or regulations. Now, second thing is, what time period? Okay? The answer is clear. The answer is you look at the founding era, when the Second Amendment was written, to look to see what was the gun laws at the time of the founding around 1791. And the best evidence that we do that, there's tons of evidence here, and I'll tell you why. There's a little digression about it in a moment. And this is an example where I can criticize everyone, including Justice Thomas, who we love. I'll get to that in 1 second. The reason why it's 1791 is when was the Bill of Rights written? When was it adopted? In 1791. And remember, the notion of originalism is what? We go to the time the document was written, and we try to understand the public understanding of the document when it was written. When it comes to the Bill of Rights, that was 1791. 1791. So you got to go back to 1791, which means if you have all these anti-gun black code laws in the late 19th century, it doesn't affect the meaning of the 1791 Second Amendment because it's 100 years too late. 100 years too late. So you got to go to 1791. So that's the key, that time period. And we know the Supreme Court agrees with this because if you look at the dictionaries, remember, interpreting the plain text is what? Semantic linguistic. So what did the Supreme Court do in Heller to define all the terms of the Second Amendment? They went to dictionaries written by lexicographers, which is a fancy word we use at Oxford for people that write dictionaries. Okay? They go back then and they looked at the dictionaries at the time of the founding. Noah Webster, who was an American English lexicographer, Samuel Johnson, who was the English lexicographer, and some others. And this is where they got the terms of the Second Amendment because that's when it was written. These were the dictionaries used by the Founding Fathers to write the Second Amendment and the rest of the Constitution. So that's why that's consulted in 1791. Now, the anti-gunners are desperate, and watch this game. They're desperate to make the year of our Lord, 1868, the key year to interpret the Second Amendment. And their reason is because there's a lot more gun control laws in the late 19th century. Why is that? Because after the American slaves were freed, you had a whole bunch of states actively were terrified of blacks carrying guns. And they started passing all these gun control laws with an understanding, wink, wink, nod, nod, that if you're a white guy, don't worry about it. If you're a black guy, we're gonna come down on you a ton of bricks and put you in prison. And those black codes and all that late 19th century sort of stuff that came out of the post-Civil War era means there's a lot more gun laws. And the reason why that's important is because the burden is on the government to show a historical tradition of firearms regulation. They're much more able to show a historical tradition of firearms regulation in the late 19th century because there's a lot more gun control laws on the books for them to draw from. That's why the anti-gunners must win that 19th century fight. So never let them get away with this. And I'll just give you two reasons why they cannot possibly win is, one is the Supreme Court has universally said like 1,000 times that when you're applying the Bill of Rights to the states, to the 14th Amendment, the meaning of the constitutional right is the same as applied to the federal government as applied to the states. So there would be no logical reason to use the 1868 understanding of the Second Amendment or the First Amendment as applied to the federal government, which was created in the late 18th century. See, that doesn't make any sense. Moreover, there's countless Supreme Court precedent, including a very famous case dealing with the First Amendment called Espinoza. And this is a good case to know. Espinoza versus Montana was a First Amendment case about 5 years ago, written by Chief Justice John Roberts. So squishy guy, right? Not hardcore like John Roberts. And what he said in the Espinoza case, which is about the understanding and meaning of the First Amendment's right to free speech and right to religion and right to free exercise of religion and establishment of religion, what he said was this. Even though in the late 19th century you had 30 states had these anti-Catholic laws that prevented public money from being spent on Catholic schools, religious schools, you had 30 states. The majority of states in the late 19th century, after the adoption of the 14th Amendment, had laws that said you cannot use public money on private schools that are Catholic or that are religious. Chief Justice John Roberts in the Espinoza case says, those 30 state laws do not establish a tradition of regulation of our First Amendment rights because they come too late in time. 30 states. I can assure you there are not 30 states in 1791 that have any kind of gun control law to speak of outside of don't commit murder, okay? So the Espinoza case teaches us that even John Roberts understands that the 18th century meaning of the Second Amendment is what gives, not the late 19th century. Okay, so must be a government regulation. We don't care about period on the government history, a particular time of history. Actual regulations must be at the time of the founding. And what else? How do we use late 19th century? This is the only thing I want you to understand because there's a sleight of hand here and I want you to make sure you pick up on it and write about it correctly, and that's this. You will see people like Justice Brett Kavanaugh, and even I might say, that late 19th century post-Civil War laws are relevant to the Second Amendment. Hear what I just said? Are relevant to the Second Amendment. And you're like, well, Mark, isn't that inconsistent with what you just said? No. Here's why. Late 19th century laws involving the Second Amendment are relevant to the extent those laws are what are known as confirmatory analytics, to the extent that they confirm the 1791 understanding of the Second Amendment, they can be considered relevant. But to the extent late 19th century laws are inconsistent with the plain text of the Second Amendment, they're verboten. Does that make sense? So 19th century laws can be relevant to the Second Amendment, but only as a one-way ratchet, as a confirmatory analytic to confirm the 1791 understanding. They cannot undercut the 1791 understanding. So when you see the anti-gunners say, like, it's 19th century is highly relevant, yes, but make sure you add on that language, because that's the game they play. It cannot contradict the plain text. And the last point I want to make about this, and then we'll move on, take a few questions, if any, and then I'll carry on, is this. And this is very important to understand, and this will make you happy. And no one uses this, what I'm about to tell you. I'm telling you, I'm the only person in America that uses this, no matter how many times I torture Second Amendment lawyers. And I think it's because they forget about this when they write their briefs. Silence is our friend. Ambiguity, when it comes to history, is our friend. Don't believe me. Believe what the U.S. Supreme Court literally wrote in 2022 in Bruin. This is what the Supreme Court wrote about if you have a historical record that is ambiguous. And ambiguous means you have multiple interpretations with different outcomes that are all reasonable, right? There's reasonable interpretations, but they lead to multiple different outcomes that are opposite of each other. That's an ambiguity in the law. If you have ambiguity in the historical record, what do? Do we throw up our hands and say the government wins? That's what the anti-gunners want you to think. That's what the anti-gun judges want you to think, that when there's any doubt, the government wins. That's the opposite of the Anglo-American tradition, which is why if there's any doubt in a court case, you're not guilty, you're found innocent, you're acquitted. Likewise, when it comes to the Second Amendment. Ready? Here's what the Supreme Court said when you have inconsistency or ambiguity in the historical record. Quote, Justice Thomas in Bruin, quote, in a footnote, because the Second Amendment's bare text covers public carry, the respondents, that's New York State, New York here shoulders the burden of demonstrating that New York's proper cause requirement is consistent with the Second Amendment's text and historical scope. Now, the headline, here it is. To the extent there are multiple plausible interpretations of Sir John Knight's case, which was the historical fight they had, we, the Supreme Court, will favor the one that is more consistent with the Second Amendment's unqualified command. If you have historical ambiguity, they defer to the text of the Second Amendment as written by we the people. Don't forget this. This is often get lost, and this is literally in the majority opinion in Bruin, and for some reason, a lot of people seem to forget it's there. So when you're dealing with history, if there's a debatable proposition on both sides, we win, they lose, never forget that. And quote that language. Quote that language in your working. Okay, so I'll give you guys 2 minutes of break. Go ahead, any questions for 2 minutes? And then I'll torture you some more. Okay, let's just hit the highlights of the top 5 or 6 myths and mistakes that the anti-gunners make in the different genres of case. Okay, the ones that are most common. Remember, all this is taking place in front of a backdrop where the anti-gunners are trying to make originalism fail, the Second Amendment fail, and they want to disarm you because you cannot become a European peon if you have guns. And they know this, and they got to get the guns. Okay, now, this is very important. If you only remember one thing about the biggest mistake that the anti-gunners make, I'll say 2 things. When you apply the in common use test, which says that if an arm is in common use by Americans for lawful purposes, number 1, it's not just self-defense, it's just ownership, right? Just owning the gun is using the gun. So when it says in common use, it's not just bang, bang and self-defense, it's just the mere possession of it. That's the first thing. The second thing is, okay, we're gonna do a little test right here. Here's the test. The in common use derives itself from the historical tradition of firearms regulation of dangerous, unusual, when you could regulate the dangerous and unusual weapons in a society. Therefore, if something is in common use, it cannot be dangerous and unusual, because if in common use, it cannot be unusual, and by extension, it cannot be dangerous and unusual. Question, plain text, burden shifting, historical tradition of firearms regulation. Where does the in common use fit in that little hierarchy? Exactly, historical tradition. And because the in common use test is part of the historical tradition of firearms regulation, why is that super duper good for us? Cheryl? It shifts the burden to? Exactly, and means what? And never forget this, you gotta remember this. The government bears the burden to show that AR-15s, the AK-47 suppressors and magazines are not in common use. Just like if you indict me and I sit in the courtroom and I look out the window and watch the birds fly by, that's all I have to do as a criminal defendant. I don't have to do anything. The burden is on the government. So too when you're dealing with arms regulation, arms ban cases. If they want to ban an AR-15 in New Jersey, the burden of proof to show that those AR-15s are not in common use is on the government, because it all occurs in the context of the historical tradition of firearms regulation part of the analysis. Never forget that. So when these people out there in the Second Amendment community, who I will not name, but they're out there saying like, we need experts, we need evidence. No, you don't. You don't, because at the end of the day, the anti-gun judges are going to throw you under the bus, period. They don't care. We only care about the Supreme Court, and we're going to win at the Supreme Court. Every member of this current Supreme Court has said in one form or another that AR-15 semi-automatic rifles are in common use. All of them, including the liberals, because there's no debate about it. So, all right, that's the first thing. So, in common use is not just for self-defense, it's for all lawful purposes. Number two, the burden is on the government because it's at the historical level. And this is number three. This is extremely important because this is the biggest fraud, in my view, that the anti-gun courts commit. And I actually wrote an entire article in the Harvard Journal of Law and Public Policy about this, but you only need to hear this one sentence, and that's this. How many of you, when you read these articles in these cases, they refer to like, oh, mass shootings with guns, it's like unprecedented societal change, and these weapons are so much more dangerous. It's unprecedented, it's new, it's right. You hear all that language? Where's that coming from? Where's the legal hook? And the answer is it's coming from Bruin. But it's coming from, in my view, a fraudulent citation to Bruin. Okay? Here is what the full sentence reads in the Supreme Court's decision in Bruin talking about unprecedented social change and change in technology. And then you'll see exactly where the game gets played, and you'll be like, oh my God, I can't believe they've been doing it to us. The Supreme Court wrote in Bruin this, talking about historical analog laws to figure out when the historical burden is satisfied by the government. Quote, while the historical analogies here in Bruin, listen carefully, and in Heller are relatively simple to draw, other cases implicating unprecedented societal concerns or dramatic technological changes may require a more nuanced approach. Oh my God, do you see what just happened there? They literally said, in cases such as Heller, they're talking about other cases other than Heller. But Heller is the case that defines when is an arm protected under the Second Amendment. This language about unprecedented societal concerns and dramatic technological change is specifically not talking about the Heller in common use test. It's not talking about arms ban cases. It's not talking about any of that. It's talking about other cases. And what happens is you watch these anti-gun courts just quote, they would say unprecedented societal concerns or dramatic technological changes. They do not write in the entire sentence. Go check me out. Go check out these cases that have used this language and find out how many of them have just read the entire sentence that I just read to you. And you'll find a bunch of them don't do that. They skip right to the language, ignoring the fact that Heller was reaffirmed, and because Heller's reaffirmed the in common use test and the burden shifting to the government, all of which was reaffirmed, they pretend it wasn't. So never let them slide that by you. Suppressors and magazines. Suppressors and magazines. The anti-gunners will like to say that suppressors and magazines are not arms because you can't pick up a suppressor, you can't pick up a magazine and do anything with it without the gun, so therefore they're not arms. Now that's hooey for two reasons. Again, my job here is to give you the language from the Supreme Court. In the Supreme Court 2022, Bruin said specifically, expressly, you can look it up, that a modern arm is protected under the Second Amendment if it is, ready, an instrument that facilitates armed self-defense. An instrument is an object. Is a magazine an object? Yes, it is. Is a suppressor an object? Yes, it is. Do these facilitate armed self-defense? Obviously they do. So under that sentence in Bruin, an instrument that facilitates armed self-defense, both magazines and suppressors, are indeed arms. Number two, step back for a second and think big picture. What happens if I ban magazines that hold more than 10 rounds? What is the effect of that ban in, let's say, the state of New Jersey, if I ban magazines that hold more than 10 rounds? That is, there's a little nuance, but write it down and you'll understand it, right? That is actually that is a firearm ban on an entire category of firearms. Specifically, if you ban magazines that hold more than 10 rounds, you have banned an entire category of firearm that is capable of firing more than 10 rounds without needing to be manually reloaded. Okay, same with a suppressor. If you ban suppressors, what have you done? You've banned an entire category of firearms capable of firing suppressed fire. So they not only is the language of Bruin tell you these are arms, but so too is the reality of the category of ban on a type of firearms if you ban either of these parts. So the Supreme Court is likely going to grant cert on whether or not 18, 19, and 20-year-olds have a right to keep and bear arms. And I want you to be aware of how the anti-gunners are going to attack this and how to respond to it. The right of the people to keep and bear arms shall not be infringed includes the people. We know that at minimum it's all American citizens, right? So any American citizen is protected under the people at the textual level. Now, therefore, the burden shifts to the government to show that you can ban guns for 18, 19, and 20-year-olds. And they have to come up with some sort of history to do that. Well, it's very difficult for them to come up with history that says 18, 19, and 20-year-olds do not have full-blown Second Amendment rights for, among other reasons, the Militia Act of 1792. The Militia Act of 1792 says all able-bodied white males between the ages of 18 and 45 have to bring with them their very own firearms, their very own cartridges, their very own ammo. So it would seem very odd that the entire country, remember this is a historical tradition that covered the entire country, would require 18, 19, and 20-year-olds to bring their own firearms with them if they could not get firearms in the first place. So you have very favorable affirmative proof to show that anti-gunner arguments are wrong. Now let's go beyond that though, because this is the critical argument, and I'm going to slow down because it's a little tricky, and this is the main argument that the anti-gunners are going to make on the young adults, and I want you to understand it, and I want you to understand why it's wrong, okay? Because they're going to sound smart, and then you're going to blow them up. Okay. It is true, is Alan Beck here? Okay, Alan Beck, I'm going to use Alan Beck to help, because he did excellent research on this. We'll get to that in a second. Okay, ready? 18, 19, 20-year-olds are part of the people. They're American citizens. We know that. Do you want to ban them from having guns? The burden shifts to the government to show historical tradition of firearms regulation. What are they going to point to? They're going to point to commercial law dealing with commerce, business transactions, because at the time of the founding, it is true that you had a lot of laws on the books that said that 18, 19, and 20-year-olds were considered minors for the purposes of a particular type of consumer protection statute that said that 18, 19, and 20-year-olds and minors, at the time they turned 21, had the right to void contracts if they wanted to. This is about protecting young kids from basically being manipulated and exploited by unscrupulous merchants. Okay? That's how it works. So what the anti-gunners say is, well, see, there's this voidability law. It applied to all products, which include guns, and that shows that 18, 19, and 20-year-olds were minors, and we could take away their right to have guns. Well, in addition to the 1791 Militia Act opposing that, the two reasons why those consumer protection laws do not hurt us are these. Number one, if you think about it, and this is where Alan Beck comes into play here, there was an exception to those rules, and it was called the necessity exception. And the way it worked is this, that yes, if you're 18, 19, or 20, and you bought a product from someone, and then at the age of 21 you thought you were snookered, you could void the contract if you wanted to. But the exception to that was if what you were buying was a necessity, food, and of course firearms, because there is no more necessity other than common sense. You need guns to hunt and protect your family. It was necessity because you had to have guns to comply with federal law, the Militia Act of 1792. Right? So they're going to say, so there's an exception that Alan Beck did an excellent article on, I encourage you to read it, explained there was a necessity exception to that rule, and guns were a necessity, therefore the exception applies. Right? And of course, Alan, any other points you want me to make here on this point, since you're the guru on this?
Just the only citation I have is pistols, and that didn't really apply to long arms.
Got it, okay. Excellent. The only other thing I want to mention is this, because I know I got 30 seconds left, is this. The other reason why those commercial law statutes are not applicable is they're not firearm regulations, and the law is that the government bears the burden to show there's a longstanding tradition of firearms regulation, and if you got a consumer protection statute, that is not a firearms regulation. That's a consumer protection statute, and therefore it's not part of a tradition of firearms regulation in the United States. So be on alert, because I think there's about a 90% chance the Supreme Court is going to grant cert in one of the young adult cases this year, because there's a circuit split and there's several cases up there, and I think it's an easy one for the Supreme Court to rule on, and we will win that one, we will. So anyway, I hope this wasn't too much after lunch and everything else. Hope you aren't bored, so thank you for hanging in there.
Orders up. Table 2A.